Hi there, my name is Jane Wesley Brooks. I'm a certified family law specialist with JWB Family Law in San Diego, California. Welcome to Tuesday's Tips. Today's topic is contempt of court. What is it? How do you file for it? What does it mean? Contempt of court, you've probably heard the slogan a lot. TV likes to glamorize and say, oh, you're in contempt. Well, contempt of court pretty much means you haven't been following the court's orders. You have violated the court's orders. Where we see this a lot in family law is if somebody hasn't been paying their child or spousal support. Then they are in contempt of court for failure to pay. But it could also be you're not following a custody and visitation plan, or you haven't been paying the property division as ordered by your judgment. That's a violation of the court's order, and you are then in contempt. However, to say you are in contempt, only a judge can say you are in contempt. You have violated an order, but a judge determines if you are in contempt. How does that happen? Well, the person who has not been receiving their child support, spousal support, or the property division properly has to file a motion for contempt. And they have to outline everything that was in order and that it was not paid or it was not followed. They have to delineate all the different instances of violation and offer proof. It then goes to a hearing. And what's going to happen at that hearing is the court is likely going to appoint a criminal defense attorney to the party who has been violating the order. Why? Because a contempt is actually a quasi-criminal issue or matter. And so the person who is allegedly in contempt has the right to counsel. And so they are typically appointed a criminal defense attorney that is on a list of criminal defense attorneys that the court uses for contempt proceedings. When you do file for a contempt proceeding, the person must be served personally, even if they have an attorney, which typically attorneys will allow service between their firms without a process server. But if it's a contempt hearing, that must be served personally. And so I just want to tell you that the first hearing, it is likely nothing's going to happen. There's going to be an appointment of counsel. And then at the next hearing, that is when the court will hear the contempt issue and make a ruling as to whether that party was in contempt. I hope that helps you understand better contempt and how you go about filing a motion for contempt and what to expect once you've filed the motion, that you have to personally serve it and that you're not going to have a hearing on the issue of contempt the very first time you go. I wish you the very best, and I really hope you never have to be involved in a contempt hearing. They're not fun.